Hello everyone. Today we will discuss a new topic in banking and insurance law. Today we will discuss about liability under Consumer Protection Act 1986. We will see how Consumer Protection Act 1986 is applicable in banking industry and how banks are liable for the deficiency or any liability which they owe to their customers. The list of topics to be covered here is banker and customer relationship, although we have already discussed about it in previous lectures. Then we'll talk about how a bank's customer is a consumer, the liability of a banker under the Consumer Protection Act, what is the ombudsman scheme, and few case studies. Banker-customer relationship. Customers are the consumers in banking industry as they are availing services provided to them by banks. The relationship between banker and customer is fiduciary relationship. It is based on trust among them. Basically, a customer trusts the bank with the deposit of money when he opens an account, and the bank also trusts its customer when they advances or provides them loan. The RBI has involved itself in strengthening the fiduciary relationship between the banks and the customers, as it holds the responsibility of maintaining the financial health in the Indian banking sector. At the same time, RBI has a major duty in building up a strong consumer confidence amongst the general public by ensuring the stability and safety in the Indian banking system. So basically, RBI sees how the customers are uh, taken care of and how they are maintaining their relationship with the banks. Bank's customer is a consumer. As per Section 2, Clause D of Consumer Protection Act 1986, the term services includes banking services also under the purview of the Act. A person availing banking services for consideration is a consumer, and to enable him to bring an action against the bank, it is necessary for him to avail the banking services for a consideration. Liability of a banker. The bank is doing this work on a commercial basis and is being paid by the company to accept applications on its behalf. Hence, even though the applicant may not be paying services charges to the bank, the service is not free. The applicant thus becomes a beneficiary of the services hired by the company and hence is entitled to file a complaint against the bank for its negligence and deficiency in service. A complaint against the bank can be filed. Here we can see that a customer who avails any service from the bank, whether he is opening an account with the bank and depositing money, or whether he is presenting his check for honoring by the bank, or we can say if he is taking advances or loans from the bank, in any of these, if bank found at the deficiency of services, then the bank will be liable under the Consumer Protection Act. A bank can be held liable under Consumer Protection Act 1986 if any deficiency is found in services provided by bank. Deficiency means inadequacy to the quality or state of being deficient, an amount that is lacking or inadequate, a shortage of substances necessary to health. So here we can see a deficiency means the inadequacy to the quality of the services, where a bank refuses to provide services to its customer or does not provide the particular quality of the services which bank has been guaranteed to its customer, then that would be considered as a deficiency in services by the bank, and the bank can be held liable under the Consumer Protection Act. Some examples of deficiency of services by bank are deficiency of service on the part of the bank where it dishonors the check without any justification or misplaced a check received by post or deposited for collection, etc. Let's talk about banking ombudsman scheme. The banking ombudsman scheme under the is a impartial and a conciliatory approach. In India, any person whose grievances against a bank are not resolved to his satisfaction by the bank within a reasonable period, then the customer may approach the banking ombudsman for the redressal. Now, let's discuss about the banking ombudsman. Now, what is a banking ombudsman? Banking ombudsman is an alternative dispute resolution mechanism for resolving the disputes between a bank and its customer. Reserve Bank of India has also set up Customer Service Department to act as a nodal department in the RBI for grievance redressal of complaints received from the public. So every bank or most of the bank in India opens a office which is for the banking ombudsman. The banking ombudsman particularly created to resolve the disputes which are between the customers and the banks. This particular banking ombudsman deal in the resolution method. When a customer faces any deficiency in services, they can complain about that particular thing to the banking ombudsman of the particular bank or the branch, and the banking ombudsman will resolve that particular dispute between a bank and its customer within the reasonable time. The department is renamed as Consumer Education Protection Department (CEPD) and continues to focus on providing a level playing field between suppliers and consumers of financial services by easing the imbalances arising from information irregularities, inadequate disclosures, and unfair treatment. When we come across the recent initiatives of RBI in consumer education and protection, we find the formulation of the Charter of Consumer Rights, which includes five basic rights of bank customers. They are right to fair treatment, right to transparency, fair and honest dealing, right to suitability, right to privacy, and right to grievance redressal and compensation. Let's discuss Let's discuss few case studies where court has held that how customers of a bank will be considered as consumer. In Punjab and Sindh Bank versus Manpreet Singh, it is a case of 1994 where it was held by the Punjab State Commission that a savings bank account holder is a consumer under the Act. It was observed that difference in the lending and borrowing rates is the consideration for the rendering services by the bank. It was also observed that even if the bank does not charge for providing check facility to the account holder, it cannot be said that the same is given without consideration. Actually, the checkbook facility is obtained by the depositor in consideration of his putting funds at the disposal of the bank. Another case is in Vimal Chandra Grover versus Bank of India. It is a case of year 2000. It was argued before the Supreme Court on behalf of the bank that the appellant who took overdraft facility from the bank by pledging shares is not a consumer within the meaning of the Consumer Protection Act. The Supreme Court repelled the arguments of the bank and held that the bank is rendering services by providing overdraft facility to a consumer, which is not without consideration. Bank is charging interest and other charges as well in providing the services. Provisions for overdraft facility is certainly a part of banking and falls within the meaning of service as provided in section 2 clause 1 clause O of the Act. Here we have seen how In different cases, Supreme Court has proved that the bank and its services will be considered under the Consumer Protection Act, and any deficiency for the services of the provided to the customer by the bank will be considered as a deficiency, and in that particular case bank will be held liable under the Consumer Protection Act.